The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. We'll call the first case, United States versus Collington. And just as a little check here, Mrs. Albro, can you hear me?
Yes, sir, I can, Your Honor.
Okay, Ms. Hummel, can you hear me?
Yes, Your Honor.
All right, we'll hear argument from Ms. Albro first and then go on from there.
Thank you, Your Honor. It's Kimberly Albro here on behalf of the appellant Chuck Collington. And the issue in this case today is how far does the discretionary clause found in Section 404C of the First Step Act extend under the circumstances of this case, when there is now no dispute that Mr. Collington was convicted of a covered offense, that the district court applied Sections 2 and 3 of the First Step Act as if they were in effect at the time Mr. Collington was originally sentenced, and the resulting guideline range is the statutory maximum of 240 months under the First Step Act. In other words, does the discretion allow the district courts to disregard the statutory maximum limits? I believe, and Mr. Collington submits, that this court's Chambers decision all but answers the question. Mr. Chambers, like Mr. Collington, was deemed eligible for a sentence reduction under the First Step Act. He was convicted of a covered offense, and Mr. Chambers was no longer a career offender under the intervening retroactive case law. The district court declined to change the career offender status of Mr. Chambers, and this court held that the district court must correct a retroactive guidelines error in a first step resentencing. The Chambers at page 672 said, in effect, the First Step Act makes the sections of the Fair Sentencing Act retroactive. In effect, the error here is the same. It's both a guidelines error, because the guidelines error is the statutory maximum of 240 months. Given the mandatory nature of the statutory maximum in the First Step Act, Mr. Collington makes an even stronger showing that the error in his case should be corrected. There is a limit on the discretion of the district court, and it was fully outlined in the briefing, so I don't want to go over everything in the brief unless the court has questions about the limits outlined there. But
Ms. Albro, going back to Chambers, which I'm kind of familiar with.
Yes, sir.
The problem in that case, he was designated a career offender, and then when the First Step Act was passed, he wasn't. And that was really the issue, as opposed to the amount of time, wasn't it?
That was the issue, is whether he was a career offender. But nonetheless, once the guidelines were recalculated for Mr. Collington, and he had a statutory maximum of 240 months, which is also, like I said, was also the guideline range, the question becomes whether the First Step Act under the discretionary clause would allow the court to disregard a statutory maximum. And if Chambers found that retroactive guideline errors were correctable, it seems that a statutory limit would certainly be required for the court to impose in a First Step Act resentencing.
Well, do you think that in First Step Act cases, whether or not you're right or wrong on the discretion, that it should be judged for procedural and substantive reasonableness? In other words, even though the judge doesn't change his mind, he should at least put some clear reasoning in his decision.
That's correct, Your Honor. Since the courts have held, and this court has held, that the 3553A factors apply, I certainly think that if the district court, which I believe they did not in this case, fully examined the 3553A factors, that warrants a remand, especially specifically in this case. Mr. Chambers submitted a sentencing memorandum when the court requested it after, I believe it was after the sentencing reduction report came out, to argue why his sentence should be reduced in accordance with the sentencing reduction report. And he included all of his history of classes and the different things he had done at the BOP. And as you know, the district court made its decision using its discretion, what it perceived as its discretion, not to apply the new revised sentence under the First Step Act. But it was done in a text order, and nothing was mentioned at all about the mitigating factors that Mr. Collington presented as a reason for his reduced sentence. Also, I believe it's substantively unreasonable because the whole purpose of the Fair Sentencing Act and now the First Step Act is to give relief to those defendants who were harshly punished under the crack laws as they were at the time they were sentenced. So the mandatory minimums and the statutory maximums were altered to reflect that policy, to give relief from these what have been determined as racially disparate sentences. So I do believe that applies. I believe the language of the First Step Act supports that discretion is limited on the district court, because the as-if language, even in the most conservative of cases, for example, what the government argued in the Chambers case is that the First Step Act is limited only to applying sections 2 and 3 as if they were in place at the time the defendant was sentenced. Even if this court has disagreed with that, I believe the Fifth Circuit in Hegwig, which was distinguished in Chambers, also followed the government's position that that this as-if term is limited simply to applying the provisions of the First Step Act. But even under those circumstances, there's a new mandatory minimum, a new statutory maximum, which under any other circumstance, as outlined in the briefs, is not within the discretion of district courts. And unless the court has further questions, we would rely on the briefs.
All right, thank you, Ms. Albro.
Thank you.
Ms. Hummel?
Thank you, Your Honor. May it please the court, Lauren Hummel on behalf of the United States of America, we ask that you affirm district court's decision declining to reduce Collington's sentence under the First Step Act for 2 reasons. First, under the plain language of the statute, relief under Section 404 of the First Step Act is discretionary. And second, the district court properly exercised its discretion under the Act in declining to reduce Collington's sentence. Turning to the first point, relief under the First Step Act is discretionary. First, the statute specifically uses the word may, which implies a degree of
I don't think you're going to get much argument that it's discretionary. I think the question is whether the court abused discretion. Let me ask you this. If a defendant is sentenced today for drug trafficking in an amount of 5 kilograms here?
Yes, Your Honor.
What would be the maximum sentence imposed today?
Today, if the defendant were charged with a threshold weight of 5 kilograms, yes. Your Honor, he would be subject to, as a matter of fact, even greater penalties because he would meet the requirements under Section 841B1A for the 10-year minimum.
20 years, right, today?
Yes, sir.
Max.
Excuse me, Your Honor, no.
And the various statutes applicable here have made that change. In other words, to go above the 5 kilograms, to get a bigger sentence, you have to have 28 kilograms charged, right?
No, Your Honor, you would have to have 28 grams. I believe I misunderstood your question.
I'm sorry, yes, 28 grams, I'm sorry, yes. All right, so the various statutes made that change retroactive, right?
Yes, Your Honor, the
so
statute...
So that this defendant had to be sentenced under 841 with a threshold of 5 grams with a maximum sentence of 20 years. And if a judge sentences you above 20 years for that violation, it'd be an illegal sentence, wouldn't it?
If the court were to impose a sentence today, yes,
Yeah.
Your Honor, that would be an illegal sentence.
And if you impose, when you make something retroactive, that means that same rule was applicable at the time, in this case, Mr. Collington was sentenced.
No, Your Honor. At the time,
Why not?
At the time Mr. Collington was sentenced, his statutory maximum was 40 years.
Of course, but that was changed retroactively. What does it mean to be retroactive?
Here, under the First Step Act, it means that the courts can give the defendant the relief that Congress has provided within their discretion, as the First Step Act notes.
My question is, to make something retroactive means that it was applicable then as it is now.
Your Honor, I would submit that.
Is that right?
I would submit that.
Give me your definition of retroactive.
Your Honor, retroactive would imply that it predates, so that the defendant can receive the relief under.
Not can, Congress said must. You can't be sentenced for more than 20 years under the statute, right?
If the defendant, that is correct, Your Honor. If the defendant
Statute of conviction, that's what we look at. Worsing says we focus on the statute of conviction.
Yes, Your Honor.
And the statute of conviction applicable here has a maximum of 20 years, both now and retroactively when he was sentenced.
Not when he was sentenced, Your Honor. He was subject to a maximum of 40 years. Your Honor,
Well, he was at that time, but they changed the law, and then they say it's retroactive, right?
under the First Step Act, it's not required to be mandatorily retroactive. It, in effect, allows defendants to receive that relief, but it is not mandatorily retroactive, which is
What was the act that changed the law?
the act that changed the law was the Fair Sentencing Act.
Fair Sentencing Act. All right.
Yes, sir.
And that act was made retroactive, right?
The Fair Sentencing Act was governed by Section 404 of the.
Oh, I said, was it made retroactive?
It was not made mandatorily retroactive, Your Honor.
I didn't ask mandatorily. I said, was it made retroactive?
Under the First Step Act, under your definition, Your Honor, I don't believe it was. Under the First Step Act,
Don't the sentencing guidelines have a maximum sentence of what the statute provides, and the sentencing guideline was made retroactive?
Your Honor, I don't believe the sentencing guideline was made retroactive in this case.
So it's your position that 20-year maximum for the statute in this case was not retroactive. Is that your position?
That's correct, Your Honor. It is discretionary, and if Congress had decided to make it,
no, that's two different concepts. Two different concepts, because if it was made retroactive, then to issue a sentence beyond the statute is an illegal sentence. And a judge who imposes an illegal sentence or lets one stand, as a matter of law, would be abusing discretion. A judge can't enter an illegal sentence.
That's correct, Your Honor.
All right, so the whole question is whether the change in the sentence for 5 grams is retroactive.
That's correct, Your Honor.
Okay, and you say it's not.
It is discretionary under the First Step Act, Your Honor.
Discretionary isn't a question. Tell me where retroactivity is made discretionary. Retroactivity means it's either in effect or it's not. I don't understand the notion that retroactivity is an optional idea.
And that's noted by the plain language of the First Step Act. The plain language.
The First Step Act says a judge may refuse to reduce a sentence.
That's correct, Your Honor.
But the question is, may he not reduce a sentence when the effect is to leave an illegal sentence in place?
That is correct, Your Honor, and I believe that is noted by the plain language of the statute. It notes specifically, nothing in this section shall be construed to require a court to reduce any sentence pursuant to this section.
Well,
Therefore,
I thought you agreed that the statute of conviction today mandates nothing more than 20 years.
if the defendant were charged today and sentenced with 5 grams of crack cocaine, yes, Your Honor, the court would be required to impose a sentence of 20 years. However, the defendant has not been charged and sentenced today. The defendant's sentence at the time was legal. It was valid within the statute.
Let me ask you this question. Could the district court in the resentencing sentence him to something that was imposed at that time, what you call illegal, but what the Congress has now declared to be an illegal sentence that would be today, and illegal based upon the policy of which it was done? I don't see the incentive of the government to want to push for an individual to have a sentence that Congress has said, we made some mistakes. If you go and look at the underlying reasons, there's some reasons. They're saying they're disparate. You heard that word racial? They did this on purpose, and they did it with information that was not correct. Congress is trying to correct something. It has some political restraints in doing it directly, and now the courts are moving in a direction. You're pushing the courts in a direction to say, well, just ignore those constraints that Congress has. Congress is trying to say, courts, you do fair and you do justice. Why don't you do right here? And we're going to give you the vehicle to do it. And yet the government comes and pushes, oh, the heck with what Congress wants and the heck with what this evidence is. They say it's discretionary, and you create this term discretionary retroactive. I agree with Judge Niemeyer. I do not believe there's such a thing. There's nothing between retroactive and the way it is in perspective. I mean, it's either retroactive or not. But let me ask you this question. Could the district court impose a sentence that's between the current sentence, that is a sentence that was imposed back then, and the statutory maximum now? Could it impose a 25-year sentence now?
No, Your Honor, and that is noted specifically by the First Step Act because it
so
provides
no, you gave me my answer. I got you. I agree with you. I do not believe it can. If it's not, what you're telling me is stuck between maintaining a severe sentence and not reducing the sentence at all. That's the only choice you're telling me the court has. Is that correct?
The question
listen to my question. Listen to my question, because that's a very simple question, and I think you've answered it. And that is, the court, under your interpretation, can only impose either the sentence that was administered or not reduce it at all.
The court can either reduce the sentence within the constraints of the Fair Sentencing Act that would be applied at the time the covered offense was committed, or the court can decline to reduce a sentence.
But it couldn't give a sentence between that current sentence and the maximum sentence here.
No, Your Honor, I believe that's correct.
So you see where I'm going with that? You see where I'm going with it? The court is restrained. You've just taken a whole chunk of a sentence opportunity for the court away under your interpretation. Between 40 and 25 years, cannot get that sentence. So he can only get 40, or he got to drop down way to the statutory maximum.
Yes, Your Honor, and the reason is because the court is imposing a sentence. The court cannot impose a sentence.
The reason is because that is what you're arguing here today. I mean, it doesn't seem to follow at all. I mean, I don't see why this is such a major issue for the government to pursue, that when you're dealing with retroactive under the Fair Sentencing Act. Congress is seeking to do something here. Congress has done it. It comes to the court, and in fact, the court and the government figures out a way to basically say, well, some folks we're going to do this for and some folks we're not. That can't be fair. A different judge could rule differently, is what you're telling me. And I understand that is the phenomenon in sentencing. But when you're dealing with this kind of situation, the role of the appellate court, we ought to try to make sure that the very purpose of the Fair Sentencing Act, and the reason we have these strictures on sentencing, we ought not have different defendants having to depend on the nature of the judge and the government's position in different cases as much as we can. We want the judge to have some discretion. We want him to do things, but there's guidance here provided by Congress. So don't you think we ought to provide that guidance in light of what Congress intends, the language here that's in the statute, the Fair Sentencing Act retroactivity?
Your Honor, I would submit that Congress has provided that guidance.
Surely they have. I agree. They have. The problem is we, the courts now, are put in a position, do we now thwart that which Congress has provided for by seeking to work around it for some folks, but not for others? It all depends on the judge. You've handled it. Did you actually do this? Were you in the trial court on this?
I was on the First Step Act motion, yes, Your Honor.
Have you had cases in which judges would rule differently on a similar situated case?
That is possible. I do not recall a similar case to this one, specifically because the defendant had such.
Do you have any problem in saying that perhaps it makes a great difference on which judge it goes before for this particular issue?
It could depend on a judge, but more importantly, Your Honor, it depends on the facts and circumstances.
And do you have any problem in saying that it ought not to make that big of a difference for a defendant, depending on the judge, particularly when Congress has indicated its intention? I understand discretion. When you give these guidelines, you give ranges. They're always there. But here we have something we all know in this room right now, something is wrong with the way this was done. We knew it then. And finally it comes up, Congress goes through its policy decision, has testimony. You had people to testify before Congress. Let me remind you, you know this. It went up there and said, well, you know, this crack cocaine is really worse than powder cocaine by far. It is horrible. Turns out it's an absolute lie. It is not even close to being any different than powder and crack. And yet the sentence disparity that Congress worked out for that previous one reflected that. And we know it was aimed, or it had the effect of affecting poor and minorities in far greater numbers than others. And as much as we want in our country to not do that sort of thing, and we want to, but we don't want to have to come back and admit it. I understand Congress is not going to come back and admit that straight up. It creates this opportunity for the court to do justice. So tell me, tell me how is the justice served here by undertaking the position you take in this case? Tell me.
Sure, Your Honor. And in this case specifically, if the defendant had been charged under the Fair Sentencing Act and sentenced under the Fair Sentencing Act at the time of his conviction in this case, he would be subject to the same penalties under the Fair Sentencing Act as he would have been if the court decided to reduce his sentence under the Fair Sentencing Act. The penalties wouldn't change. His drug weight was so vast. He was held accountable for over 5 kilos of crack cocaine, and I would note specifically.
Would it have made a difference if he'd had 5 kilos of powder cocaine?
If he had 5 kilos of powder cocaine, I believe he would still be subject to the same penalties.
So you're saying that the penalties for powder cocaine and crack cocaine were the same back then?
No, Your Honor. I am saying that the threshold of cocaine would have been met by that drug weight. The threshold of crack would have been met by an enormous amount, because only 280 grams are required to meet the threshold minimum for 841B1A.
Today, he was charged with a 5-gram amount, and today the most he could receive for that offense, regardless of the relevant conduct, and the relevant conduct shows he had many more grams than that. That's amply shown. But if he were sentenced today, regardless of how broad his conspiracy was and how many drugs he trafficked in, he could only get 20 years.
If he were sentenced under that threshold today, yes, Your Honor, that is correct.
That maximum is incorporated into the sentencing guidelines, right? As the maximum.
It is, Your Honor. The sentencing guidelines become the
guidelines were made retroactive, were they not?
The guidelines in this case are not made retroactive. If the defendant is sentenced under.
I thought, and Chambers noted, that the changes in the Fair Sentencing Act were made retroactive by the First Step Act.
The court in Chambers, I don't believe, noted that.
Is that, I just want to know the principle. Is that an erroneous principle? I'm maybe operating under a totally misunderstanding, but I thought the First Step Act made the Fair Sentencing Act retroactive.
It did not make it retroactive because retroactive implies that it would be mandatory, whereas the First Step Act
It does not.
provides this
Retroactive means
discretionary.
it's applicable. It means today's rules are applicable back then, nunc pro tunc. In other words, the retroactive has nothing to do with discretion. That's the second step. The question is, okay, now it was a legal sentence when imposed. It would not be a legal sentence today. If the sentence for today was made retroactive, then you have the question, when the judge leaves that sentence alone, he's leaving alone an illegal sentence. And then the question comes, now when he's asked to make it retroactive, he has discretion. And the question is, what constitutes an abuse of discretion? And of course, the final step would be he leaves in place an illegal sentence. It seems to me that's not a hard step to conclude, that you can't do that. And Chambers basically says that, right? They're the qualifications for heavy sentencing because the career offender status was made retroactive, right?
Career offender status, yes, Your Honor, but not the statutory
And so that
maximum.
became an illegal sentence to apply. Even though it was legal when applied, retroactively it became illegal because of the change.
That is correct. That is what the Chambers Court decided. In this case, Your Honor, the Fair Sentencing Act has not been made retroactive in that sense. The defendants are eligible for a reduced sentence. However, nothing requires the court.
I understand that, but I thought you told me it would be illegal sentence today, sentence this gentleman today, more than 20 years for that statute violation.
Under the same threshold amount of drugs, and today,
everything,
yes.
Everything the same, but today he got a max under this statute of 20 years.
Yes, Your Honor, if a sentence were imposed today. But I think the key is whether the sentence is imposed or not. Here,
well, that ignores the concept of retroactivity, but I understand your position.
and one, I believe I have only a few more seconds. I would just like to note, unless the court has any other questions, I would like to note the spirit and the fairness of the Fair Sentencing Act. I believe Judge Wynn pointed on this earlier.
And what the impact of procedural reasonableness should have in our decision here.
The impact of procedural reasonableness, Your Honor?
Yes.
Your Honor, I believe that the procedural reasonableness of this sentence is noted by the court's decision and the reasons that the court gave.
My question is really, is in resentencing, must the judge do so with procedural reasonableness and support it with some type of compelling justification when you have this great of a variance between a sentence?
I believe that this court has determined that a court imposing a resentence.
Understand my question. I'm not being argumentative. I'm just trying to understand your position on that. And that is, understand the question. The question is simple. If you have this big of a variance and the judge has this wise discretion, must the judge employ procedural reasonableness and support it with some sufficient compelling justification to indicate why that variance is going to be allowed at the higher end?
The court does have to justify its reasons, yes, Your Honor. And in this case, the court did that. The court noted the seriousness of this offense.
Well, I think the court was impressed by the notion of the murder cross-reference.
Yes, Your Honor.
A 30-year sentence was appropriate for that conduct regardless. And I think that came through pretty clearly, that was why the court stuck with its guns. The only question I have, and I'm not speaking for the other judges, but the question I have is the impact on these two acts on that sentencing. And one act reduced the sentence, but that could only be prospective. And then the second act seemed to make it retroactive. You say not so. The second act, of course, didn't require a judge to make an adjustment. but there's a big range within an original sentencing. And in this case, the range that the original sentence authorized goes beyond what would be legal under the retroactive sentence. That's my only concern. And I understand your position about the discretion, but the whole question here, and the judge has a lot of discretion, and we've approved it in case after case. Judges have said, I'm not going to reduce the sentence because of this or that. But the question is, when you're faced with a Chambers type situation, which I think this probably is, because the criteria for the original sentencing have now been changed and undermined the original sentencing if it were sentenced today. And the question is now, is it an abuse of discretion not to recognize the illegality of continuing with an illegal sentence now, as Chambers observed? That's my question, and I guess you're saying retroactivity can be applied discretionarily, even though Congress seemed to indicate that it wanted this to apply in hindsight.
Yes, Your Honor, and I think Congress noted specifically that it wanted it to apply discretionarily, and that's noted by Section 404C when it said that nothing requires the court to reduce the sentence.
And I think you're right on that. The only question is if you have a new sentence, if you have a change which now makes the old sentence illegal, in other words, if you're in a range of 0 to life, the judge can choose to reduce it or not, because life's the maximum. But here, it was 40 years reduced to 20 years. And the judge originally gave 30 years, which is now above the 20 years. And the question is, what's the consequence? And as a policy matter, we would be trampling, wouldn't we, Congress's purpose in trying to get all these back in line with the 2010 Act?
No, Your Honor, because Congress made it discretionary. The sentence is still legal today, and the court can decide not to reduce the sentence under the Act. And then, of course, there's a piece of discretion at that point.
Okay.
Thank you for your time.
That cover it?
Yes, Your Honor, I believe so.
Okay.
Thank you for your time.
Thank you. You held in. Ms. Albro? You'll have to unmute whatever. I can't hear you.
My apologies. I did have it muted during Ms. Hummel's argument. I would just address a couple of points that came up during the government's argument.
Can I ask you, before you get into that, can I
Sure.
ask you what your understanding is about whether the First Step Act made the Fair Sentencing Act retroactive or not?
I believe it did make it retroactive, and I believe that in Chambers, this court said, I mean, the quote is, in effect, it, referring to the First Step Act, makes those sections of the Fair Sentencing Act retroactive. So it was referring to sections 2 and 3 of the Fair Sentencing Act and how those sections became retroactive via the First Step Act. And it wasn't anywhere in the briefing, but the Jones case out of the 11th Circuit 962 F3D 1290 refers to the district courts applying the reduced statutory penalties for crack cocaine offenses retroactively. So I do believe
the government's question is the whole application of the First Step Act is an application that is discretionary. The court can step back and say, I'm not going to grant the relief. I look at it, and for reasons of the seriousness of this, I think in this case, basically it was the murder cross-reference, but the judge said, I'm not going to engage in the First Step Act and exercise the discretion not to even apply the analysis. But the question is, when it exercises discretion, it is applying it because it gives discretion. And then the question is whether it is an abuse, I think.
I do think that the discretionary clause, even in these circumstances, it is confusing because it's not explained that there are limits on it. But as I cited in my brief,
I don't know if there's limits on it. It's a question of what constitutes an abuse. As you know, as a general principle, if a court commits an error of law, that constitutes an abuse of discretion. The Supreme Court's noted that many times. And so the question is whether this is an error of law to let stand an illegal sentence. And I think that's the issue. The discretion's there. I don't think if we're going to honor Congress, we have to honor that too.
I think that it's retroactively applicable, and that's where there becomes a tension between.
It seems to me your colleague seems to take issue with that, saying that Fair Sentencing Act could be retroactive in some cases and could not be in other cases. And I'd like to look at that closer again before coming to any conclusion for myself.
Yes, Your Honor, I believe the discretionary clause as written in the First Step Act and retroactivity, that those two things, it's hard for those two to coexist. And I do believe the First Step Act is retroactive. And
is there a guidelines? Is there a new guideline that makes the sentence change retroactive?
I don't know if there's a new guideline. I know at the time that the Fair Sentencing Act came out, those changes were incorporated into the sentencing guidelines, and there was a provision that they were retroactive, such that my office filed many motions related to that because the Sentencing Guideline Commission did allow for those changes to the guidelines to be applied retroactively. So to the extent that those are incorporated because the First Step Act made the Fair Sentencing Act retroactive, I suppose it could be tied in that way. But to be fair, I haven't researched
various guidelines that made changes retroactive in order to have people who were sentenced under a stricter drug trafficking scheme to have the benefit of a more lenient scheme.
Well, when a person, maybe I'm
guidelines those are, but
well, there is the most favorable guidelines should be applied. So usually when a defendant is sentenced, he's subject to the most favorable guidelines.
Well, I understand, but my whole question is focusing on retroactivity, because nobody is disputing the fact that the judge imposed a legal sentence in this case when imposing it. The whole question is what happened after that in terms of not only the sentence, the statute under which he was sentenced, which we know was changed, but then the question is whether the guidelines in the Fair Sentencing Act and the First Step Act gave somebody earlier the benefit of that.
Yes, Your Honor. I see my time is up. I don't know that I can answer your question because I'm not certain. I haven't looked into it, or I'm not certain what guidelines that you're referencing.
Well, I'm not sure either. That's why I'm asking you.
So I apologize. I don't know if there's something that I'm happy to look into it if the court would want supplemental briefs after argument.
Anything else? Okay.
Thank you, Your Honors.
Thank you. Appreciate this discussion, and nothing that I've said indicates where I'm going to be coming out. I've pressed you sort of hard on this. Normally, our practice is to come down and greet counsel at this point, and it's a tradition that I think the whole court values. Obviously, we can't do it today, but I want to extend our gratitude and pleasure with hearing your arguments. And when you come again the next time, I hope we'll be able to shake hands. Thank you very much. We'll proceed on to the next case.
Thank you.
Thank you, Your Honor.
See, counsel, let me just ask Mr. Clement, can you hear me?
I can, Your Honor.
All right, and Mr. Barber?
Yes, Your Honor.
All right, why don't we proceed with Snyder's Lance versus Frito-Lay, and we'll hear from you, Mr. Clement, first.
Thank you, Your Honor, and may it please the court, Paul Clement for the appellants. The decision below dismissing this case for want of jurisdiction finds no support in text or context and contradicts the weight of authority in the leading treatise. Although Frito-Lay has belatedly embraced the district court's jurisdictional theory, it raised no objection for the first 2 years that this case was in district court. That was not a failure to issue spot, but it reflects instead the fact that the statute here plainly gives a party dissatisfied with a TTAB decision a clear choice in seeking review. If the primary concern with the TTAB decision is legal, then the statute gives an appellate right to the Federal Circuit. If instead the TTAB decision implicates disputed questions of fact, then the statute also gives the party an option to proceed in district court where there's a de novo review of the facts and an ability to add to the record. But the statute recognizes that both avenues have their advantages and their disadvantages, and it gives parties a choice. Now, Frito-Lay, for its part, of course, concedes that my client, Princeton Vanguard, had that choice with respect to the 2014 TTAB decision. And my client filed an appeal in the Federal Circuit. Frito-Lay has a statutory right to object and kick that case to the district court, which it did not exercise in 2014. So we proceeded on our appeal to the Federal Circuit. My client won before the Federal Circuit, and the Federal Circuit then vacated the 2014 decision. Now, when the case went back to the TTAB after that decision, there was no TTAB decision from 2014 because it was vacated. So the TTAB then issued a new decision in 2017 that was quite different from the 2014 decision, because the 2017 decision not only applied the correct standard of law, as clarified by the Federal Circuit in its 2015 decision, but it also went on to address a wholly second question, the question of sort of secondary meaning. And if you want just a dramatic illustration of how different the 2017 decision is from the 2014 decision, you can just put the two decisions side by side. The first one has. So
let me ask the question. In sending it back from the federal court, it was not just a remand to correct or clarify from that perspective, from your perspective. Your statement is that it vacated the previous decision?
Yes, Your Honor, that's clear from the Federal Circuit decision itself.
Would it be a difference if it had not vacated it? If instead it simply had remanded for reconsideration or for some to look at a different evidentiary point or something of that nature? In other words, not a full vacation of it, but really asking it to clarify something.
Your Honor,
does that make a difference?
Well, I think it makes a difference in the sense that it would be a harder case. I still think my position would be the same.
Well, the reason I'm asking is because I think the vacation of it seems to, that makes a lot of sense. Vacation, as in subject matter jurisdiction type situation, if you vacate, it just wasn't there. So it makes a lot of sense. But my question is, does that necessarily follow? Because once we do this and we say you can do it, it necessarily, even though it may be an issue for another day, it is right there. It is our basis to be based upon the fact that it was vacated by the Federal Circuit.
So, Your Honor, it's not my job to make this case any harder than this case is, right? So I would be happy with a decision that rested on the vacatur. And I think the only precedent on the other side, which is an unpublished district court decision from the District of Columbia, fits the harder case that you're envisioning. That was a case where, at least as the way the DDC read the earlier Federal Circuit decision, it actually read it as retaining jurisdiction and just sending it back for clarification.
So that can be done? Can be done? The Federal Circuit could have said, we retain jurisdiction over this matter, in effect foreclosing that opportunity. You believe that is could have been done by the Federal Circuit here?
I don't think so, Your Honor, but I would admit, I'd be the first to admit it would be a harder case, but I would still be making the argument that I'm making. I think, it would be a harder case. I also think my friends from Frito-Lay might have raised the objection right away in that context in the district court and not waited for 2 years. and I don't mean, I mean, obviously it's a jurisdiction, if it's a jurisdictional issue, it doesn't matter that they waited, but, you know, they have fine counsel. And I would submit that the fact that nobody noticed this for 2 years is some evidence that the statute on its face, although every statute can be clearer, and one of the references to waiver is using a passive voice construction that sort of, you know, creates the issue. I understand why we're here, but I do think the better reading of the statute, the better reading of the context and the case law says that we could have the right to file in district court, even under the circumstances that you're envisioning, Judge Wynn. But I think when there's a vacatur of the first opinion and you start over, our ability to go to district court ought to be particularly clear.
Well, let me ask one last question. At least it seems to me, if you're resting on the plain language of the statute, that all those little nuances I just mentioned wouldn't make any difference if the plain language of the statute creates this right. Is that right?
I think that's right, Your Honor, and that's why I said, although that would be an easier case, I would still be, or you know, or the hypothetical would be a harder case, I'd still be making my same argument. Because, and I do think that, you know, the statute as a whole makes clear that what it's focused on is the particular TTAB decision under review. Now, as a textual matter,
one last question, and I'm gonna let my colleagues weigh on this because I know they're ready with questions too. One concern is the Federal Circuit gets the appeal, and I take it there is some nature of a law of the case or some rulings that they made that then binds the parties or binds the board below. Why wouldn't it just seems like that would be, once you make that choice in the first instance, that's your choice. And you had the option, both parties had the option of going under Section B, but chose instead to move with A. And once you go there, you're there. And otherwise you're going to be, every time it goes back, let me ask you this question, because I know that's getting somewhere. What if the opposite happens? You choose to go to the district court, it goes back. Now can you go to the federal court under the statute the same because of the plain language, even though you have been allowed to potentially present counterclaims, all kinds of extra stuff before the district court, as opposed to going to the federal court? Does that change when you reverse it?
When you reverse it, you still have the option the second time around. And you can ask my friend on the other side of that question, but I think
going to either one. My question is to go into either one. So you're saying the answer is yes, you can do the same thing if you go to district court first and go through an entire proceeding. District court sends it back. On the second time around, you can say, okay, we'll go up to the federal court.
Yes, Your Honor, you can have that option if it happens in sort of the reverse order. I would point out that my understanding of my friend's position is that they would agree that if it went to the district court first, the second time around, you could go either to the federal circuit or to the district court. Now, maybe he'll correct me, but that's my understanding of his position, which I think shows that his position is a little bit anomalous, because it means
well,
that
it seems to follow, because to go to the federal court, wouldn't both of you have to agree to do that?
We would have to both agree to be in the federal circuit.
So it seems like the parties could agree to go to a different form, but in this instance, to go to the district court, in other words, to not go back to the federal court, you simply only need one not to agree, which is what happens here.
Sure, Your Honor, but that's built right into the statute. Even in the first instance, you can't go to the federal circuit unless both parties agree, but either party has a right to force it into district court. And so I think that's, again, shows the anomaly of my client being foreclosed from going to district court, because the way that the statute's set up, you have an initial choice, but there's actually, if anything, sort of a default preference for the district court, because either party can force it there. And I don't think Congress ever envisioned a situation like this where you'd be foreclosed from district court with a particular TTAB decision. And I think it's important to recognize, Your Honor, that we're not running from the federal circuit because we got some ruling there that we're trying to evade. We won in the federal circuit. So if anybody would have an incentive to keep this case out of the federal circuit, it would be Frito-Lay. And I think under their position, if we filed in the federal circuit in the first instance, their view is they could have made an objection and forced us into the district court. I think that's got to be their position because that's how they distinguish the Seventh and the Ninth Circuit cases that we rely on. Now, I think that's important because I don't think there's too much of a concern to the law of the case issue because the Supreme Court's made clear law of the case applies across circuits. But in the scenario where the party who lost in the federal circuit, who has the greater incentive to try to stay out of the federal circuit, which in this case is Frito-Lay, because we won the first time, they lost, they can force this case into the district court, where the district court's going to have to apply the federal circuit law, and if it gets appealed to this court's going to have to treat it as law of the case. So
in which instance, then your position would be flipped. You'd be on the other side right now, probably arguing that position, and he'd be there saying we can't.
Well, Your Honor, we all have clients, but
I understand that.
My point is that there is nothing about our position that creates the anomaly that you could be in district court and having to apply the federal circuit decision as law of the case.
Well, that's a little bit. It seems to me there are things to be said on both sides in this case. The statute seems to focus on the decision and gives the option with respect to a decision, a TTAB decision. That's that's your fundamental position. The waiver doesn't seem to be limited, and the argument on the other side is that once you make that election, then you've made it for the whole game. The one aspect of that argument that has some appeal is that if we were to allow this going back and forth, we would have the Fourth Circuit monitoring and applying or trying to apply the Federal Circuit's mandate. And the bigger question comes, what if we were to disagree and say, as a court, we think we want to change our mind. There are exceptions to the law of the case. And a district judge who makes the decision early in a proceeding basically ought to continue the proceeding under the law of the case to give some predictability to the parties. But later in the case, there's nothing that says the district judge can say, I've been thinking about this, and I think I made an error on that, and I'm going to change my views and write an opinion, explain why, and give the parties full and ample opportunity to respond in that fashion. I think that might apply also to the Fourth Circuit when we're looking at a Federal Circuit opinion. And at that point, you get to the unseemly notion where you have two circuits could be disrespecting each other. I would think in the more normal circumstance, the various circuits show a lot of respect for each other and their laws and their decisions. That to me speaks a little bit for the notion that the waiver might be broader. On the other hand, the waiver is there with respect to a decision. And in this case, without getting to the ones that Judge Wynn had questioned, which are much closer, in this case, there was a vacatur, a broadening, there was a whole secondary meaning issue that's developed. And of course, secondary meaning is very factual, and maybe the district court's a better place to handle that type of thing. So I don't think this is a slam dunk for either side. It's a little bit of a call we would have to make. And it seems to me in this case, it raises both sides pretty well.
Well, so Judge Niemeyer, if I can, let me try to explain why I think that although you've identified factors on both sides, they weigh pretty heavily in our favor. So the one is, if the law of the case is your primary concern, I would say a couple of things about that. One is, this isn't the only situation where you can have that dynamic. And if you look at the Christensen against Colt Industries decision that we cited in our brief, that's a situation where there was basically a circuit split within a single case and it went up to the Supreme Court. And that's very unusual, but it can happen. So we're not creating some anomaly here. The second thing I would say, though, is even if you would, at the margin, want to interpret the statute to make that happen less often, what this situation that's arisen here is not a common situation. I mean, there's a reason that when we look for circuit court cases, we're offering you a 1967 Seventh Circuit decision and a 1970 Ninth Circuit decision. These subsequent TTAB decisions are relatively rare. So if your concern is that in these two TTAB decision cases, you might have to wrestle with law of the case issues, that's probably a problem that's going to vex you maybe once a decade at most. But the problem is,
remember, in patent cases, you often see one party files in one circuit on a straight-on claim of infringement, and the other goes to another circuit and seeks a declaratory judgment of non-infringement. And the Supreme Court has issued some rules about it. Of course, the second filed case tries to broaden the issues so as to give some legitimacy to the declaratory judgment action. And the Supreme Court has talked about that. I don't remember the name of the case, but it arises and it can be handled. I understand that. It's
yes, Your Honor, and I think it's worth recognizing that in the patent context, Congress tried to minimize that to the absolute extent it could by creating the Federal Circuit, requiring all the patent appeals to go there, and they made a different judgment with respect to trademark. So, I think that's entitled to some weight in the balance. But if I could, the one point I just want to make before I sit down, because my time's already expired, is on the other side of the ledger, here's the problem. Although this situation arises with the second TTAB decision very rarely, you don't know that when you're deciding what to do with the first TTAB decision. And so if you create this dynamic where you're forever bound by your first choice, then all sorts of lawyers are going to advise their clients that you got to go to the district court. You can't go to the Federal Circuit, because if you go to the district court, you preserve your option if there is a second TTAB decision. And the second
let me before you finish up and on that point, I'm just curious. If you look at section 1071A4, and it states specifically regarding the Federal Circuit, this language shall govern the further proceedings of this case. So that sort of, the way I read that, it tells me, if under Judge Niemeyer's scenario that I too have concern about, but it looks like to me, if it comes to us, that section says that's what governs the proceedings of this case, the Federal Circuit. The problem I have with it is I don't see a section down here that says, well, if it comes to the circuit courts, the federal circuits, that the circuit courts shall govern the proceedings in this case. So it seems to create the conundrum that we may be bound by the Federal Circuit's proceedings in the case, but they are not bound by our proceedings. Is that your reading of that, or does that have any applicability here? I'm trying to understand how that comes into play.
So, Judge Wynn, I read that provision as being most specifically directed at the TTAB in the remand proceedings. So it's just making crystal clear to the TTAB board, the TTAB, that it's to follow the Federal Circuit decision, because the rest of that subsection, that's A4, is directed to kind of the timing and the record, and it's all directed to the TTAB. Now, it's fair, though, I think, that you could read that as being almost a statutory rule that reinforces law of case principles.
It sounds to me like it's a mandate rule. It basically says the Federal Circuit's mandate shall apply to the further proceedings down below before the TTAB. But
that's how I read it as well. That's how I read it as well, Judge Niemeyer. That it's more directed.
But there's a little. What Judge Wynn raises, a little bit of a broader inference might flow from that.
But it does go further than just the mandate. It says the mandate and the opinion to the director. And then that's when that's entered, that shall govern the proceeding, not just the mandate. So that's what causes me concern here. And I'm not asking these just hypothetical questions just to be asked. You know that. If we write this opinion, we've got to figure out how to write it in the narrow way that you want us to do, or it has a more expansive application that's going to cause us headaches in the future of trying to figure out why did we write such a thing as that. You see where I'm going with it? So that's why this is coming up.
No, I understand.
Go ahead, just finish. You can respond to Judge Wynn.
Yeah, no, and all I would say is I understand that, and you know, to go back to where I started, I would say that, you know, if you want to rest it on the vacatur of the 2014 TTAP decision, we don't have any objection with that. It would narrow it. And the only thing I would say about that particular sub 4 section you're looking at is that does show that Congress knew how to refer to something having continuing effect throughout the proceedings, as opposed to being focused on the decision. So I actually think that provision sort of reinforces the point that Judge Niemeyer alluded to as on our side of the ledger, that the focus of the statute's on the decision. But thank you, Your Honors.
Thank you. All right, Mr. Barber.
Thank you, Your Honor, and may it please the court. When a party in a TTAB proceeding loses and wants to appeal to a court, it must make a decision at that point. It must either appeal to the Federal Circuit under subsection A of 15 U.S.C. 1071 or file a civil action in district court under subsection B. And with that decision comes a binding election. Under the plain language of the statute, if the appellant chooses the Federal Circuit, it waives its right to file a civil action. That's what the statute says.
I think what you say is pretty clear, but I think the question is whether that rule applies to the review of a decision from TTAB, or whether that rule applies to a future decision of TTAB after a remand from the circuit court. And I think the second situation is not as clear. The question really is, obviously Congress wanted to give an option to litigators. One is a little bit more efficient maybe on the record, and it's a little more expensive to go to district court, but district court will give you some discovery. You can add issues and counterclaims and so forth. So Congress really provided that, but it seems to me that decision to give that option would be based on what confronts the lawyer. And what confronts the lawyer is the TTAB decision. Now, if the TTAB decision were of a totally different color, the lawyer might make a different decision where to go. So in this case, we had one decision, the 2014 decision, and both parties agreed to let that go to the Federal Circuit. We have a 2017 decision, which I think it's fair to say is different. You can argue, but it really does raise additional issues for a lawyer making the decision where to review that. And the problem is, do we say that's still part of the initial proceeding and the waiver goes all the way through? Or do you now have a fresh choice in view of the new decision? And I don't think there's a slam dunk in reading the statute, but there may be some pragmatic and policy decisions that should be made in light of what Congress is trying to achieve.
Well, I think there are, Your Honor, and I think there are three reasons we would point to that we think are pretty compelling why the waiver when you first appeal to the Federal Circuit applies throughout the remainder of that case. First is the plain language of the statute. The waiver language in subsection A isn't limited to a decision or an issue or a time period. It's tied to the party. It says the appellant waives his right to file a civil action. So that's number one, is the plain language. But beyond that, if you accept Princeton Vanguard's position here that appealing to the Federal Circuit only precludes the appellant from filing a civil action on the same TTAB decision and doesn't apply to additional decisions, that makes the waiver clause in subsection A completely superfluous, because subsection B alone, which provides that a dissatisfied party may file a civil action unless appeal has been taken to the Federal Circuit, is sufficient by itself to preclude an appellant from also appealing the same district court, the same TTAB.
But you know, what you just quoted probably structurally doesn't solve the problem, because what you just quoted, it says dissatisfied with the decision of the director. And so the procedure that's being discussed is in the context of a decision of which a party's unhappy with. And the question is, if you get a second decision, do we apply the same procedure, because the waiver may be construed to be broader than just the decision, or do we link the waiver to the particular decision, recognizing that maybe a new decision might raise different issues. I mean, there's a certain pragmatic justice here too. Both lawyers want to have a fresh decision if there's a new decision. I mean,
I think,
fresh choice if there's a new decision.
I think the point I was trying to make is it does apply to future decisions. When you file the first appeal to the Federal Circuit, it does apply to future decisions, because if it doesn't, the language in subsection A, the waiver language, is superfluous. It's not needed. And
Well, sure it is, because you can't, it says it gives you time periods. In other words, you can, party A says, I'm going to the district court. Party B, I mean, there has to be some kind of an agreement. And once that agreement is made, you've waived your right to go anything else. But the open question is still whether that's with respect to that decision being reviewed, or whether that's with respect to the whole case, regardless of what happens in the future.
right, but the language in subsection A wouldn't be needed for that.
Well, sure.
If you remove the language in
Because
subsection
the waiver, once you've made the election go to the Federal Circuit, you can't reverse it and say to the Federal Circuit, I'm withdrawing my appeal, and I now want to go to the district court. That precludes that.
right.
Once you've gone through that initial process and you're in the Federal Circuit, you can't go back.
Correct.
That's what that says. Now, it could also mean what you're saying, but I'm just suggesting it's not as clear as just making a categorical statement saying that's superfluous. It seems to me it serves a purpose even with respect to a decision.
I agree it serves a purpose. I'm saying it would be superfluous if Prince of Vanguard is right that in their position. The language in subsection A would not be needed, because under the language of subsection B by itself, the party that filed the Federal Circuit appeal could not file in district court. You wouldn't need any language in subsection A. The third reason that I think it must apply to all future decisions is really sound policy, and this gets to some of the questions Judge Wynn was asking. The appeals of TTAB decisions to the Federal Circuit under subsection A and district court reviews under subsection B are really very different animals. And one big difference is that the Federal Circuit, of course, can and often does remand the case back to the TTAB, and then the TTAB's decision on remand can go back to the Federal Circuit, and it can go back and forth until the Federal Circuit is satisfied with the TTAB's decision. That's not so in a district court review. Once a civil action is filed under subsection B of the statute, that case never goes back to the TTAB or to the Federal Circuit. I think.
Well, let me ask you that question. That I think it's a good point. Is there a remedy that the district court can issue that would send the case back to the TTAB for some clarification or some fact finding?
No, that's not how it works. The district court is given broad discretion under subsection B to decide whether the applicant is entitled to a registration or any other matter that's required by the case. So the district court makes all of the decisions, and then the district court.
Could the district court send it back? A district judge might say, I appreciate the expertise that the agency has, and I'm inclined to let them look at this and send it back as opposed to entering the relief itself.
I don't believe that's ever happened, Your Honor, and I don't think that's what's contemplated by the statute. The statute says that a civil action can be filed in the district court, and the district court has full authority and power to decide whether the applicant is entitled to a registration and to decide any other matter in the case. And then, of course, the district court's decision would be appealed to a regional circuit like this court. It wouldn't go to the Federal Circuit. Now, the district court can't, at some point, will send it back to the director of the United States Patent and Trademark Office, but that's just to implement the decision on registrability. It doesn't go back to the TTAB. The district court has already decided whether the applicant is entitled to a registration or not. So it's just not how it works. And in fact, the language in subsection B says that the decision of the district court will go back to the director of the USPTO, not the TTAB. So I think that's another compelling reason why these appeal avenues.
Well, they talk about the director or in the disjunctive, director or the TTAB, right?
No, subsection B just talks about sending the decision. I'm sorry. Such adjudication, the adjudication of the district court, shall authorize the director to take any necessary action upon compliance with the requirements of law. So it's sent to the director, but not to the TTAB. The district court has already made the decision whether the applicant is entitled to a registration or not, and any other issues that arise in the case. So it goes back. Does
the director have authority to refer it to the TTAB?
You know, maybe hypothetically that could happen, but I don't. In that hypothetical, I don't know what there would be left to decide by the TTAB. The district court has already made the decision. The director may want some guidance. This is all fairly involved, obviously, and we haven't found much case law on. Right, but the director is bound by the district court's decision under subsection B. So there'd be no reason for the director to send it to the TTAB at that point. There'd be nothing for the TTAB to decide. It's just up to the director at that point to either issue the registration or deny the registration. So that's how it works in practicality. I've never seen a situation where the director would send the case back after it's been in district court, send the case back to the TTAB. I just don't think that's how it works in practice.
Let me ask you a question, and I'm asking it for clarification to make sure I'm not misguided in terms of making this over simplistic in terms of the way you present this. Effectively, you are saying that in the first instance, you have this choice of going A and B. You can appeal it, or you can submit it to another trial forum, effectively. And that trial forum then will redo the whole thing, or can redo it from the beginning, go through the process, and then you're in that venue to go up a different trial ladder. That's how it gets to the Fourth Circuit. Or in the first instance, you can choose to keep the board as your trial forum and go to the Federal Circuit. And then once you have chosen that trial forum, you don't get to go try another trial forum because you've already have this one you've chosen. Is that oversimplifying the way in which you're reading this?
No, I think that's exactly right. If you choose the Federal Circuit for your first appeal, then you should have to stay in that lane, because then you've gone to the Federal Circuit. The Federal Circuit is going to decide the case, send its mandate and opinions back to the TTAB, and at that point, once you made that decision, you waived your right to go to district court. You no longer have. And
it would fit probably, from your perspective, would it fit more in the realm of where your opponent is pushing this if Congress had created the avenue for it either to go to the Federal Circuit directly or to the Fourth Circuit directly on an appeal, as opposed to another full trial there, and you would have that option to go either way on it. But because it's effectively saying you got a choice, you start out at the board, and now you can accept that as your trial forum, and now you're going to be locked to that record at the federal level if you choose to go to the federal. Once you do that, to come back and now say, well, you don't have to be locked to the record anymore. We're going to throw it all out and go to another forum over here. Or I don't know what the language means in terms of you're still now bound by the Federal Circuit law, even though you all agree you are. That's kind of interesting to me. If it's another trial forum, then why in the world are you bound by the Federal Circuit law on it? But although it's the same case, and the so-called law of the case stuff come up, that's where it really gets confusing here. And maybe that pushes more to the points you are making, why it's a cleaner way to do it in the manner that you're bringing it. But look at the plain language of the text. There's a lot of support for your opponent on the plain language of the text. And how do we, well, let me let you comment on that.
Well, first of all, in the plain language, we think the plain language supports us. I mean, the waiver clause in subsection A is not limited to a decision. It's limited, it's tied to the party. It says the party waives its right to the district court. Now, once you go to the Federal Circuit, one point you mentioned, you should be stuck at the TTAB as your trier of fact. You're not necessarily limited to the record. I mean, once the Federal Circuit vacates the decision and remands it, the appellant very well could ask the TTAB to open up the record at that point.
You know, just getting back to the text, I don't think the text is fully, is as clear as you say. It says a person who's dissatisfied with the decision of the director or the TTAB may appeal to the Court of Appeals for the Federal Circuit, thereby waiving the right to proceed under Section B. But the whole subject of that, dissatisfied with a decision of the director or the TTAB, may do this, thereby waiving that. It seems that whole modification process could be construed to refer only to the decision of the director or the TTAB.
Well, again, I think that the plain language.
I understand your position too. I just think
it's not only the plain language, but it's also what I've been talking about the very different avenues for appeal and why it makes sense for once you choose the Federal Circuit that you stay there.
Well, Mr. Barber, let me ask you this question. That language, dissatisfied with the decision. In this case, it doesn't say proceedings, it doesn't say disputes, it says the decision. Don't we have two decisions here? So therefore, on the second decision, the company would have a right to go to the district court instead of the Federal Circuit?
I agree with the first part. There are two decisions here. But the problem in here in the plain language of the statute is that once you appeal that first decision to the Federal Circuit, you've waived your right to go to the district court. And that language in subsection A can only have meaning if that applies throughout the case.
Well, I clearly don't agree that it only has meaning there. I think it has two meanings. I think it could have the meaning you're saying, but it also could have meaning referring to waiving the right to go to district court on that decision because it modifies that decision. I think you have to acknowledge that there's that language there.
I would acknowledge that the statute is not a model of clarity, but I think the plain language supports us, and I think the avenues for appeal being totally different, and the fact that you're going to district court for a new proceeding, and that goes to the Fourth Circuit, not the Federal Circuit, all of that makes it more effective and just a better way to handle things, and probably and what Congress intended to have. Once you appeal the first decision to the Federal Circuit, that is your lane for appeal. That is your lane for the remainder of the case, and you should not be able to go to district court after that. And you know, Princeton Vanguard has failed to cite a single case where an appellant that has gone to the Federal Circuit on a first decision has been allowed to go to a district court on a second decision. There's no case that they've not cited a single case where that's happened. So I did want to address a couple of arguments that they made and why we think they're wrong, that the district court, that this makes the district court's decision wrong. They rely on the Ninth Circuit's decision in Gillette and the Seventh Circuit's decision in Tibbetts, but those cases are clearly distinguishable because there was no waiver in those cases. The party that filed the civil action in those cases was not the party that appealed to the Federal Circuit, so it hadn't waived its right to go to the district court. So now Princeton Vanguard relies on the language in subsection B that says that you can't go to the district court if appeal has been taken to the Federal Circuit, but that language is necessarily limited to the appellant in the first appeal, because the full sentence where that language reads says, quote, whenever a person authorized by subsection A of this section to appeal to the Federal Circuit is dissatisfied. The only party that was dissatisfied with the first decision in Gillette and Tibbetts was the party that appealed to the Federal Circuit. The other party had won. It had no reason to go to the district court at that point, but more importantly, it hadn't waived its right to do that. The waiver in subsection A is very specific that it's a waiver of the appellant's right, the party that appeals to the Federal Circuit. It's a waiver of his right to file a district court. So there was no waiver in Gillette and Tibbetts.
Well, there's a parallel type of conditions that are imposed on the opposing party or the responding party, and that is, number one, he has to acquiesce And the second is that if there is no suit filed within 30 days, then the TTAB proceeding stands by default. So there's a little bit of a sanction imposed on the opposing party too. It's of course the aggrieved party is the one being addressed mainly.
Right. The prevailing party does have a right to force the case into civil action, to a civil action at that point, but it doesn't have to, and it does, more importantly, doesn't waive its right to go to the district court later. The waiver is applicable to the appellant that goes to the federal circuit. The other party has not waived any right at that point. The last thing I wanted to mention was Princeton Vanguard relies on legislative history and cites the Supreme Court's decision in Hoover versus Coe. But the Hoover case and the legislative history in that case address situations involving a single decision of the patent board. And the section of the patent statute that the Supreme Court was discussing was designed by Congress to prevent the prior ability of patent applicants to file two appeals on the same patent board decision, one in a district court and one in a court of appeals. Now, it's not surprising that Congress wanted to get rid of that scheme, but it's also not relevant here. Because neither Hoover nor the legislative history that they were discussing addresses or illuminates the appeal avenues for a second PTO board decision. So the legislative history does not support Princeton Vanguard's position, and the Hoover case does not as well.
All right. Thank you, Mr. Barber.
Thank you, Your Honor.
Mr. Clement.
Thank you, Your Honors. In rebuttal, I'd just like to make one point about precedent, one point about text, and one point about policy. I'll start just with precedent because I want to clarify something. In the Seventh Circuit Tibbetts case, in the original appeal to the Federal Circuit, where the principal appeal was by the counterparty Knowles, there was a cross appeal by Tibbetts. Now, you got to read the procedural history of the Seventh Circuit case to understand that, because nothing turns on it in its reasoning. But that's kind of my point. Nothing turns on which party filed the original appeal or whether there was a cross appeal, because you need the consent of both parties to stay in the Federal Circuit. And that's why we think the Seventh Circuit and Ninth Circuits both support our position. But when my friend says we don't cite you any case where the party that appealed to the Federal Circuit then filed a district court action, Tibbetts is actually that case, because both parties in Tibbetts filed an appeal to the Federal Circuit from the original TTAB decision. So there is a case, and I don't think you can distinguish Tibbetts on that ground. Now, to get to text, look, we've discussed it all a lot, so I don't want to belabor and make points that you've already heard. I do want to say, though, one thing about the language in A1 that they want to rely on so heavily, thereby waives your right to have an action under B, that can't be a once and for all waiver, because if the other party objects to the original filing of the appeal in the Federal Circuit, the way it's supposed to happen is the party that's dissatisfied with the TTAB decision then files the action under B in district court. So even within a single proceeding, that thereby waives his right to district court doesn't mean once and forever. It just means it's making sense of the statutory scheme, which you have a choice, but you don't get two bites at the same apple, the same TTAB decision. But nothing in there supports the idea that if the first TTAB decision is vacated and you have a brand new TTAB decision, and this time the TTAB decision is much more factually intensive, that you can't go to district court. The point I want to make about policy is really just this. Second TTAB decisions after a successful appeal are as rare as hen's teeth. I mean, the last circuit decision that addressed this issue was issued when I was 4 years old. I mean, the second TTAB decision just doesn't happen very often. But first TTAB decisions happen all the time. And if you have any concerns about law of the case when there's a second TTAB decision, that's going to come up once a decade, whereas first TTAB decisions happen all of the time. And my friend's position on the other side is going to skew everybody's calculus about where to go with their statutory right to review of the first TTAB decision. And I think this case illustrates it perfectly. If you look at that 2014 TTAB decision, the issue we teed up for the Federal Circuit was a purely legal question about what you do with a compound term and whether it's generic. Because the original 2014 TTAB decision, which was short, it only had 13 footnotes, was about as simple as this. Pretzels are generic, crisps mean crackers, crackers are generic, so pretzel, crisp is generic. Now, we looked at that and we said that's dead wrong under Federal Circuit precedent. It's dead wrong under Supreme Court precedent. All three judges of this court that looked at that issue in booking.com recognized that that was wrong. That's just a glaring error. So we thought, we're not going to go have a trial proceeding now. We're going to get the Federal Circuit to fix that error. And then maybe the TTAB will get it right. And then we won't be the party seeking review next time because we won't be dissatisfied with the second TTAB decision. But came back, they ruled against us on genericness for a second time, but they made a very different opinion the second time around because not only did they fix that legal issue, but then they, as an alternative holding, got into this whole issue of secondary meaning. Now, that's a fact-intensive issue where lots of evidence is relevant, consumer surveys and all of that kind of stuff. And we wanted to get that before the district court. So we filed in the district court the second time around. There was no forum shopping because, again, we won in the Federal Circuit. We had nothing to fear about going back there. But this time the decision made sense to go to the district court. I don't think you want to interpret the statute to make somebody in my client's position have to go to the district court the first time around just to preserve their option the second time around. Thank you, Your Honor.
Are these pretzel crisps any good?
They're excellent, Your Honor, and they're in that blue bag, which is why you know they're trademarked.
I probably should ask your colleague whether he likes them too.
I like Frito-Lay's version of them.
This has been very interesting. The arguments have been very good. It's a difficult statute. It's our missed opportunity that we can't come down and shake hands. This is our tradition. We would love to do that, and we hope to see you again so that we can do that. But we do extend our greetings and thanks on behalf of the court and try to carry on that tradition through Zoom to the extent we can. All right, we'll adjourn court for the day and ask the clerk to do so. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honors.
This honorable court stands adjourned. God save the United States and this honorable court.